Your Honour, if it pleases the court, my name is Deans, initial JD. I appear on behalf of the applicant, Johnny Wishbone, in this matter. Your Honour, my client faces myriad charges, 106 of them to be exact, relating to theft and breaking and entering. Your Honour, I submit that during their arrest of my client, officers of the Queensland Police Service have failed to adhere to their legislative requirements and they have not discharged their obligations under the Police Powers and Responsibilities Act, as well as the supporting Police Powers and Responsibilities Regulation. Particularly, Your Honour, the arresting officers failed to adhere to the requirements of questioning my client, Your Honour, given that he is a particular person under the enactments, specifically an Indigenous juvenile. Furthermore, the form of the evidence submitted to the court by the prosecution against my client renders it inadmissible, and I will direct Your Honour to these issues shortly. Your Honour, my first submission as it relates to the police officer's failure to comply with regulations and the enactment is that my client is a child. The court is now aware that he is an Indigenous child. He has not reached the age of 17, Your Honour, and he was therefore entitled to be treated as such under Schedule 4 of the Youth Justices Act 1992, as well as the Police Powers and Responsibilities Act, and the supporting regulation as well, Your Honour. Your Honour, it is also relevant that my client is of Indigenous descent. He identifies as a Torres Strait Islander. This should have been plainly obvious to the arresting officers. However, their apparent lack of inquiry and subsequent dealings are a failure of their obligations, Your Honour. My third submission, Your Honour, is that during the arrest and before the initial questioning of my client at the alleged scene, the attending officers have failed to discharge their legislative obligations. Firstly, the attending officers have failed to comply with Section 431 of the Police Powers and Responsibilities Act, Your Honour, which subsection 1 of that section stipulates that a police officer must, before questioning a person, caution that person as required by the Responsibilities Code. The wording of that section clearly indicates that this is not an optional directive. The police have also failed to caution my client with respect to his right to silence under Section 397 of the Police Powers and Responsibilities Act, as well as Regulation 26 contained in Schedule 9 of the supporting regulations. Your Honour, following his arrest, the police officers took my client into the police car and drove around the area in which he was apprehended, pointing out to houses that had been burgled and saying words to the effect of, "Did you break into that house? What about that house over there?" To which my client has given answers to the effect of, "I'm not sure, I can't remember, and I think so." My client was then taken to the city police station, which is 10 to 15 kilometres away from where he resides. He was provided with a support person, Your Honour. We have no record of who this support person was. We do not have a name. We do not know what role this support person has. The support person advised my client to just tell the truth and just answer the police officer's questions. Your Honour, I again draw your attention to Section 397 of the Police Powers and Responsibilities Act, and also to Regulation 26 contained in Schedule 9 of the supporting regulations. And clearly the police officers have broken some requirements here. Section 421, subsection 2 of the Police Powers and Responsibilities Act states the officer must not question the child unless, before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child, and in circumstances in which the conversation cannot be overheard and a support person is present whilst the child is being questioned. Your Honour, I submit that at no time whilst at the initial scene, later in the police car, and finally at the police station, was my client afforded his statutory right to silence, or as a child given the opportunity to have a support person of his choosing present during questioning. This is in clear breach of the aforementioned legislative provisions. Your Honour, the offending officers have also breached Section 418, subsection 1 of the Police Powers and Responsibilities Act, being my client's right to communicate his whereabouts to a friend or relative, and also to have a friend or relative or lawyer present during questioning. Your Honour, I submit also with reference to the trait of gratuitous concurrence, which is common in people of Indigenous descent. The arresting officers ought to have been aware of this trait, Your Honour, during their questioning. I now address my second issue, being that the police officers failed to discharge their obligations under Section 436 of the Police Powers and Responsibilities Act to electronically record my client's questioning, which was undertaken at the scene of the crime, and also subsequently in the police car. It is commonplace for officers to have recording equipment, and I fail to imagine a situation where it would have been an exceptional burden for the officers to comply with this requirement, which is under subsection 2 of Section 436 of the Police Powers and Responsibilities Act. Finally, Your Honour, I direct your attention to the decision in Bunning and Cross, and also to Section 5E of the Police Powers and Responsibilities Act, which states one of the purposes of the Act is to ensure fairness, to protect the rights of persons against whom the police attempt to exercise their powers under the Act. Your Honour, I maintain that my client was not afforded the right to fair process, and the improperly obtained evidence is clearly highly prejudicial against my client. And for these reasons, Your Honour, I request that you exercise your discretion from the decision, pursuant to the decision in Bunning and Cross, and on the grounds of fairness and public policy, dismiss the Crown's evidence against my client as inadmissible on the basis that it has been obtained by improper means. Thank you, Your Honour.